Hello, welcome again. Employment Law Show. Good to have you along. John Scholes, Lior Samfiru, Tumarkin LLP, the most positively reviewed employment law firm in the land. You can check that out anytime you like. It's going to be a very informative, educational, and hopefully fun 30 minutes for you. You're going to learn a lot about employment law. If you've watched the show before, thanks for coming back and joining us. If not, first time, buckle in. There's a lot to get done on the show, especially in these times in the last year and a half. We'll get into more of that as the show goes on. But to reach out anytime to Lior and his team, 1-855-821-5900, help@employmentlawyer.ca. And a website built just for you, absolutely free, anonymous, all kinds of information on there, including the severance pay calculator. That would be pocketemploymentlawyer.ca. Coming up in the show today, 5 workplace myths that need to be banished out of there. We'll get to those in just a bit. But, pal, we always start with the week that was. What's going on with you?
John, great to be here. Always good to talk about employment law, because I think that this is the time. In the 20 years I've been practicing law, this is the time with the most questions, the most uncertainty, the most problems that people are facing about their job security. Things that they took for granted may not necessarily be the same anymore. So we are here to tell you what you need to know about your workplace rights. It may feel sometimes that there's no laws or rules. Trust me, the opposite is true. Employment laws are extensive. They're here. They protect you. They provide for a lot of help. You just need to know what the employment law is and what it says. So on this show, we'll talk about vaccinations, mandatory vaccines, being put on a layoff, being let go, being harassed, mistreated, you name it. We'll talk on this show about that like we do on every show. And if you have any questions that are not covered on this show, no problem. As John said, we'll give you that contact information throughout the show today, so you can reach out to me privately if you want. But to get us started, John, let me tell you about a situation that came across my desk. Probably the biggest issue that I've been getting asked about recently has to do with losing your job with vaccines. And specifically, if I don't get a vaccine, do I get severance and do I qualify for EI? The federal government made a statement about EI and suggesting that some people won't, in fact, be qualified for EI if they lose their job because they refuse to vaccinate. So I wanted to break this down a bit. So the only time you would not get severance or EI is if you are terminated for cause. Now, a termination for cause, hopefully our regular viewers know this, is a situation where you're let go because you've done something so bad, so terrible, that it's impossible to continue employing you. That's very difficult to establish. And bottom line is this: in most cases, if there's no government mandate that applies to you, if you lose your job because you did not get the vaccine, that is not a termination for cause. That would be considered a termination without cause. So 2 things flow from that. Number 1, you get severance, and severance can be as much as 24 months' pay. But the other equally as important thing is you should qualify for EI, for employment insurance. That could pay you for a year. That's a significant amount. Now, there's the reality here is that chances are your employer may treat it as a termination for cause. They may give you a record of employment that says you're terminated for cause. They would not allow you to get EI. That's why this has to be dealt with properly. If your employer maintains that they let you go for cause because you didn't get the vaccine, or you're now banned from getting EI, we need to deal with your employer. We need to get them to issue a new record of employment, to pay you the severance that you're owed, again, up to 2 years' pay. So it's that much more important than it even usually is to contact me, to contact my team if you lose your job because of the vaccine. It's not just about severance, it's about EI. And John, those entitlements can be very significant. You
know, we've talked about it so many times in our companion radio show about this whole government mandate when it comes to vaccines. And I think it's worth clarification. Again, the difference between a mandate if you're in a government employee or you're working for the government or a government, you know what I mean? There's a difference between the two, right?
So the federal government has implemented some rules. Specifically, what they've said is that if you work for us, for the federal government in certain core positions, then you have to be vaccinated. And if you're not, you can't work here. So that's important. If you work for certain court positions for the federal government is your employer. In that situation, if you don't get the vaccine, you can be let go without compensation. But that's very different than being federally regulated. Right. There's many employees that are federally regulated. People that work for banks, in trucking, telecommunications. And those employees, there's no government mandate that applies to them. So if you do lose your job, can't stop that. We can't physically restrain your employer, of course. But severance has to be paid, and you should be issued a record of employment that says termination without cause so that you can get EI. So very different between working for the government, John, and being federally regulated.
Nice. Employmentlawyer.ca, that is the website you can refer to anytime, and all the good stuff. The goodies on the website, you can learn contact information. There's also a media tab. You'll find past episodes of our radio show and links to them in a station near you where you can catch the radio show on a weekly basis. But we take some of the phone calls we get from listeners live on the show, play them back here, and we talk about them. Our first call for today on the TV show is coming up right now.
I'm a senior. I'm in my 70s, and I had a part-time job. I was there for about 3.5 years, and it was about 20 hours a week. They had originally said to me I had my choice of either working out of the office for the phones or I could work from home. The vice president came and he said, well, I'm going to give you your forms. And when the form arrived from the administrator, it said that I wasn't coming back to work.
Did they offer you any severance? Did they pay you any severance?
Nothing.
Well, obviously this is wrong, and I really do, that our regular viewers are looking at this, shaking their head and saying, no, that is not proper. That is a wrongful dismissal. So let's start with the idea that the fact that she was let go in and of itself is not the legal wrong. It's not the problem here. An employer does have a right to let you go in most cases. Now, of course, we'd want to make sure she wasn't let go because of her age. She's in her 70s. We wanted to make sure that age was not a factor in the termination, because if it was, that's a human rights violation. That's illegal. But short of that, the fact that she was let go does not itself pose a problem. What the issue is severance. She says her employer is not paying her severance. Regardless of how we got to this termination, of course her employer has to pay her severance. Now, I know a lot of our viewers may think, well, she said she worked there for about 3.5 years. How much severance is she going to get? 2 weeks, 3, maybe 4 if she's lucky? No. Wrong, false, myth, whatever you want to call it. She's owed much more. Let me, instead of just telling you, let me show you. Let's go to pocketemploymentlawyer.ca. Let's input her stats into our severance calculator tool. Yep. You can do that yourself. And let's see how much she is really owed. So she's in a clerical role. We know she's been there for 3.5 years. She was not offered any severance for reasons I don't know. Well, you can see on your screen she's owed right around 5 months pay. Now, 5 months. Keep in mind, that's actually conservative. I could easily assess her as being owed 6 months pay, especially at the age of 70 plus. So that's the thing, that's the reason why it's so important to go to pocketemploymentlawyer.ca to use our severance calculator tool there if you lost your job, if you're worried about losing your job, if you're just curious about your entitlements. And there's no such thing as being let go without severance unless you did something awful.
You know, it's funny you mentioned the age being 70. I think that really highlights the important that particular piece of information is with her severance, because you think clerical, okay, not a high-ranking position. She's not a CEO, not a fiduciary. 3.5 years, not a really long work time. So 5 or 6 months would probably shock most people, but it's that age. 70, right?
It's the age, obviously, the longer you work, but also the older you are, the more severance is owed to you. But I want you to remember, and I want our viewers to remember, that short service employees, you know, people with 5 years seniority or less, are actually treated disproportionately better when it comes to severance than longer service employees. That's why it's quite common to see someone like her 3.5 years to be owed 6 months severance, even more than that. So please don't assume that just because you worked somewhere for a short period of time that your entitlements are minimal. In fact, your entitlements can be quite significant.
Why is that? Why is short-term so robust?
Well, the fact that you worked for a short term does not mean it's going to take you less time to find another job. In fact, it could take you more time because you have to explain to your new employer, why did you only work for 1 year at the old job? So because it's not going to take you less time to find another job, severance is there to compensate you, to provide you with that security until you find that new job.
Give you another website you can use, terminationquestions.com. We're just throwing at you hard this show, but it's all useful information. Terminationquestions.com, anonymous. It's free. Go there, ask your questions. Lior and his team will answer them for you and get back to you quickly. First one for today's show comes from Sandy. Sandy says, my manager's behavior has rapidly deteriorated over the last few months. He's become very short-tempered and has started accusing me of failing to finish my work on time, which isn't true. I'm extremely stressed right now, and I'm worried about what he's telling his superiors. What should I do?
Well, I think that if you're worried about your boss, in this case, building a case against you to potentially let you go, well, you have to build your own case. So if your boss accuses you of doing something that's not true, Send them an email confirming what actually happened. Boss, you told me today that I didn't finish the XYZ project. Well, here's what I actually did on that project, and here's what happened, here's what delayed me, or here's all the information you need to have. Very important. Put it in writing. If your boss says something or does something you don't agree with, create that written record. Beyond that, if you feel that your boss is picking on you, is bullying you, is harassing you, is trying to get you to quit, well, talk to someone in the workplace if at all possible. HR, the owner, whoever the right person is within your organization. And in writing, put that in writing. Make sure that they understand that this is an issue. They have to, by law, investigate. They have to. They have to take measures to rectify that problem. And finally, if you've tried that and it hasn't worked, you've talked to HR, maybe there's no HR to talk to. If you can't deal with it internally, we have to deal with it externally, meaning you have to contact me and let me deal with it. Don't be bullied, don't be harassed, no point suffering through that, and always, always put things in writing.
If you have that writing, if you send it off to your boss or supervisor, you know, explaining, detailing what went wrong, but you get no response, crickets.
I love it. No response is the same as saying, I agree. So if you send an email to your boss saying, boss, here's what actually happened, and they never respond, or boss, you did this today and no response, it's perfectly fine. It's exactly the same as if your boss accepted it. You don't need a response. You just need to show that you've sent it.
5 workplace myths that should be banished. We'll get to those, but after a short break, right? There's a bunch, but we're going to get to 5 of them anyway. 1-855-821-5900, the number anytime, help@employmentlawyer.ca. It's the Employment Law Show. Stick around, lots more to go. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks for hanging in. Employment Law Show. John Scholes, Lior Samfiru, the most positively reviewed employment law firm in the land. Samfiru, Tumarkin, LLP, co-founding partner. Right there. Okay, 5 workplace myths that need to be banished. They're myths. They're not true. Let's get rid of them because you may believe some of these. Your buddy Steve may say, no, that's true. Well, they're not. All right? It's always Steve for some reason. Steve always gets the...
Steve doesn't know what he's talking about. No.
Steve's banished. Number 1, your employer can make changes to your job whenever they want. Whenever they want.
Well, this is a myth that employers believe, actually.
Right.
Employers say, well, this is my workplace. I'm the boss. I've created this job, this company. I can decide what your job is. I can decide what to do with your terms of employment because I'm the boss. No, not so fast at all. An employer does not, despite the fact that it's the employer, an employer does not have the right to make significant changes to terms of employment. They don't. They don't have any more right to decide to demote you than you can decide you're going to be promoted. You can't walk to your boss and say, boss, I've decided effective Monday I'm being promoted. Thank you, see you Monday. You can't do that. By the same token, your employer can't come to you and say, I've decided I'm demoting you effective Monday. No, again, can't do that. Anytime we're talking about significant changes to terms of employment, this idea, this concept of constructive dismissal has to come to mind. And that's the idea that if you are facing a term or a significant change to a term of employment, you can treat your employment as being terminated. You can say, no, I'm not accepting it. Instead, I'm going to say by changing my job, by demoting me, by giving me different shift, different pay, whatever that change is, you've terminated my employment. Now you have to pay me severance. So no, there is no right to make changes unilaterally by an employer. That is a myth that we definitely need to banish.
How much do you need to highlight that word significant? Because I'm thinking if, your employer says, I'm paying you $90,000, but starting Monday I'm paying you $85,000, is that enough or no?
So when it comes to pay, usually we're looking at somewhere north or around 15% change. So if you're facing a change of 15%, that's a significant change. So if you go from 90,000 to 89, not going to be happy, but not much that can be done. If you go from 90 to 80, for example, yeah, that's a significant change. So that is something to keep in mind. Now, beyond that, anything that your employer may do that could be embarrassing, like a demotion, or anything that makes your life more difficult, like a change in hours. I used to work days, now you want me to work nights. Those are significant changes. Those are the types of changes that absolutely result in a constructive dismissal.
Okay, myth number 2 is this one. Instead of giving you time off work or accommodation because of illness or injury, your employer can simply let you go.
So some employers may think, well, accommodating someone is a big pain in the rear end. We have to find different responsibilities, maybe different hours. We have to be flexible. It's a lot of work. It may even cost us money. Let's just let them go. No, can't do that. That is a human rights violation. We have human rights legislation in every province in this country, and human rights laws make it very clear that you have the right to be accommodated. Your employer has the obligation to accommodate you, and it's a very strict obligation. Now, when it comes to medical accommodation, your doctor, judge and jury, your doctor decides what kind of accommodation you need. Maybe it's modified hours, modified days of work. Maybe you need different responsibilities, different duties. You can't lift something. You can only work certain hours in a day. You name it, your doctor has to say so, and your employer has to find a way to make it happen. Every single day I get emails from employees saying, my employer said there's no ability to accommodate and they've let me go, or they're just saying stay off on a leave. And when we dig into it a bit more, we realize, sure, the employer could have accommodated you. So no, your employer can't simply ignore that and decide to let you go. That is a myth. That is illegal if you're ever in that situation. You're not being accommodated. Your employer is ignoring your doctor. Hopefully you know what to do. Reach out to me.
I would assume that stretch of accommodation has to go further the bigger, the more resources the company has, as opposed to like a mom and pop or a big multinational company. They should be able to do more.
Absolutely. The legal concept is accommodation to the point of undue hardship. In other words, you have to accommodate, if you're the employer, until the point that it gets to be very difficult, very hard. Well, the bigger the company is, the more resources they have, the more is expected of the company, the more ability they have to accommodate, more flexibility, more positions that they have. So yes, the bigger the company, the harder it is for them to say we don't have to accommodate. But remember, even a small employer, mom and pop shop, still have that very strict duty to accommodate.
We're talking about myths in the workplace that need to be banished. Number 3 is this one. The company doesn't have to give you a severance package if you make some mistakes in your work.
So I was let go, I made a mistake, or I really dropped the ball on this project, so they let me go, they don't pay me severance. No, not so fast, not at all. The only time, I said this at the top of the show, where you get, your employer gets relieved from its requirement to pay you severance is if you, the employee, did something terrible. It's not enough to say that you made a mistake or you did something bad. Life's not perfect, we all make mistakes sometimes. It has to be the type of mistake that makes it impossible to continue employing you. We just cannot conceive having this person there. We've tried to work with them. We've tried to fix the problem. They don't get it. What more can we do? It's very difficult to do that. Your employer has to build up its case, provide you warnings in advance, let you know what happens if you don't improve. It has to be pretty bad. So remember, the fact that you did something wrong, maybe you even did a few things wrong, does not mean you lose your severance. And if you're owed severance, you're owed your full severance. The employer can't say, well, you did something kind of bad, so we're just going to give you some of your severance. Doesn't work that way. You either get your full severance or you don't get any of it. And it's extremely difficult for you to get no severance.
Myth number 4, we kind of talked about this with our first phone call in the first segment from the radio show, and this is a big eureka moment for a lot of employers, and that is your employer only need to give you a few weeks pay at most when they fire you.
So that is, we talk about myth, the biggest myth that I've ever come across, the myth that created this show essentially all these years ago, and that's the idea that, oh no, well, if we have to pay severance, it's a week per year, it's a couple of weeks, whatever it is, it's some sort of a nominal amount. Wrong, false. It's a myth that we should get rid of. Hopefully we're helping to get rid of it by talking about it on this show. And let's be very clear, severance is not a week per year or 2 weeks per year. And severance has nothing to do with the size of the company or the company's payroll. Your age, your position, and the length of your employment are the main factors. They're not the only factors, but they're the main factors that go into assessing your severance. And severance can be as much as 2 years' pay. And even if you're a short service employee, you could be owed a few months' pay. So it's very common to get a month, 2 months, 3 months per year of service. So please, it's a myth about this whole idea of a week per year. If you want to know right now how much severance you're owed, go to pocketemploymentlawyer.ca. Use our very user-friendly severance calculator tool, and you'll know the real truth, not this myth of a week per year.
Okay, for this show, our fifth and final myth is this one, and again, a lot of people believe this is true as well. It's better to resign than get fired so you don't have this blemish on your record of employment.
I get that often. I've been getting that often recently with vaccinations. Employees that have decided that they're not going to get the vaccine for whatever reasons, I don't make any judgments here, have been told you're going to be out of a job, and they've thought to themselves, well, is it better to resign? Am I better off resigning and not actually losing my job, not being terminated? No. It is never better to resign. It's never to your advantage, the employee, to resign. There's no reason to resign unless you do it voluntarily and unilaterally. People are afraid that it's going to be held against them. It's not. If you lost your job, you're getting severance. If you resign, you don't get severance. So why give your employer that gift of you resigning and trying to relieve them of that obligation? Don't resign. You work until your employer decides that you're not going to work, and at that point, your employer has to pay you severance.
I think people think there's some sort of, government database. Okay, Samfiru, you're going on the bad list, the naughty list. It just doesn't exist.
A massive spreadsheet somewhere or a vault somewhere where we keep reasons and records. No, there isn't. In fact, someone asked me about that the other day. Say, I don't want this on my record. Well, there's no record. Okay, and even if there was, it still wouldn't be better to resign than to be let go. But even so, there's no record, there's no reason as to why you would relieve your employer of that severance obligation. If your employer doesn't want you there, fine, but they have to make the move. Don't make it for them.
Employmentlawyer.ca, again, the website to find a radio show near you weekly. You can listen to. It's an hour long, lots of information just like this TV show. And phone call number 2 from that show is coming up.
My story is that I got terminated in the company, and I was working as a shop manager, as an independent contractor. And on the company premises, I was working as an hourly basis and open contract, no deadline. The question, is there any entitlement I have with this company?
John.
A manager that's a contractor?
So let's see. So we have a bunch of employees.
Right.
You manage those employees, but you're not an employee. How does that work? What is that? No, this is, joking aside, this is a common situation of misclassification. We see this often, the idea being that if someone is misclassified as a contractor when they really are an employee. Happens all the time. I promise you right now, John, there's dozens and dozens of people watching right now that are misclassified, that they believe they're contractors, but they're really employees. If you have a regular job, you go to work, you do your job, you come home, you go back the next day to do the same thing, and you take Saturday and Sunday off. You're an employee. If you're paid by the hour, generally, you're an employee. If you're supervising employees, you're an employee. So this person has been misclassified. Because of that, many things happen. Number one, he may be owed vacation pay, overtime pay, holiday pay. He certainly is going to be owed severance if he is let go. Same with you. And by the way, we mentioned pocketemploymentlawyer.ca. One of the tools that we have there is a tool that allows you to find out if you are actually an employee or an independent contractor. Again, free and anonymous. So if you're not sure, they're telling me I'm an independent contractor, but I'm not so sure I buy it. Don't hesitate anymore. Just go to pocketemploymentlawyer.ca, find out your actual status.
Want to get another phone call from the radio show, but we got to take a short break first. We'll do that now, get through it, and get back to it. 1-855-821-5900, help@employmentlawyer.ca. More Employment Law Show is on the way.
People think you have to sign back a severance offer by a deadline. Employmentlawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at employmentlawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, Don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Thanks for hanging in. Employment Law Show. John Scholes, Lior Samfiru. Last few minutes of the show. Want to get to phone call number 3 from our radio show.
My company offered me severance, 6 months. If I get a job over that 6-month period, can they stop the payments?
How long have you worked there for?
16 years.
And what kind of a job and how old are you?
Sales, and I'm 55.
So, John, I get this asked very often. So, yes, finding another job while the severance issue is still outstanding before you've actually reached an agreement with your employer on severance can reduce your severance entitlements. But why are we worried about what's going to happen 6 months from now? Because it should be possible, in fact, likely, to resolve the severance issue now within a few weeks. Forget about 6 months. And once we resolve the issue, if he finds another job, should not matter. Now, we know that this person was offered 6 months severance after, 16 years of employment. You know it's not good. But how bad is it? Let's go to pocketemploymentlawyer.ca once more. Let's input his stats into the severance calculator tool, and let's actually see how much severance he's owed. So we know that this person has been there for 16 years. I believe he said is in a sales role, 55 years of age. They've offered him 6 months. Well, as you can see there, he's owed about 18 months. 18 months pay is what he is owed. So that's about 3 times what he's been offered. And that's, again, from our radio show. It's a very common situation. So don't worry so much about what's going to happen later. Worry about getting your proper severance now. It's not difficult to negotiate. What I hope that this person didn't do is that he didn't sign off on it. Right. If he signed off on it and accepted it, even though he was owed an extra year's pay, at that point, nothing can be done. I don't want that to happen to you. If you lose your job, whatever you've been offered, make sure you call us. Let's make sure that there's nothing there that you're missing out. Once you sign, it's too late to go back.
Let's get to Katya's question quickly. Last minute or two of the show says, when I was hired, my employer allowed me to work from home 2 days to accommodate childcare responsibilities. I've just been told that starting next month, they will no longer honor that arrangement. Do I have any options here?
So it's not even about whether or not the employer should honor that arrangement. It's not about what happened then. It's a question of, does Katya still have responsibilities now, family responsibilities, that need to be accommodated, and can her employer accommodate? Under human rights laws, there's such a thing called accommodation based on family status. What that means is if you have a child care responsibility and the only way you can meet that is through support, accommodation by your employer has to make that happen. So if Katya doesn't have any other way to care for her children, if Katya doesn't have other assistance and she needs to be home with the kids and her employer can accommodate her, and we know they can because they've done it, then they have to do it. Okay, they have to provide her with that support. Now, if there's other things that Katya can do, then the employer may not have to accommodate. The first go-to is not to the employer. You have to try to see if there's arrangements you can make on your own. But if you need accommodation from your employer, flexible hours, the ability to leave work earlier or maybe come in a bit later so you can take your kids to school, your employer has to find a way to make that happen. If they don't, that's a human rights violation.
Katya, appreciate that. She reached out at terminationquestions.com. You can use that website anytime as well to ask Lior and his crew your questions. Email works. help@employmentlawyer.ca, pocketemploymentlawyer.ca. Again, you can learn tons there. And the phone call, 1-855-821-5900 anytime. Thanks for watching. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.